If someone passes away and they own property in another state outside of California, then there's some extra work that is going to need to be done. If property is owned in another state, then we would likely need to complete what we would call an ancillary probate in another state. So that is a whole nother probate proceeding in a different state concurrently as we complete the one in California. On the other side of that, we have handled probate cases where somebody passes away in another state, but they own property in California. And so we are required to complete that ancillary probate for them in California while their probate is happening in the state where they passed away. So it is important when it comes to having property, whether it's in California or in multiple states, to ensure that you understand what would happen in the event of your passing. If you are a probate executor and you are trying to manage these assets, whether they are in California or out of state, or maybe you are an out of state person trying to manage a property in California. If you are in California, you can complete a probate in another state. What that would mean is that you could contact an attorney in another state that would then be able to complete that probate proceeding for you in that state, specifically where the property is located. So in California, you can still live here while completing a probate in another state. If you are out of state and you are looking at being the executor of a probate estate, you can still be the executor in California. Generally, what the court is going to require is that there be a bond that is going to be put up in the probate proceeding, which oftentimes happen in a lot of our California probate proceedings anyways, but that's just going to ensure that the assets are protected even if you live out of state. If this sounds really messy, and believe me, it is when it gets into multi-state properties, the way to avoid this is by having a revocable living trust. A trust gives you the ability to be able to say, if something were to happen to you, here's how you want your assets distributed. All of those properties, whether they're in California or in other states, you can then title those in the name of your trust. And so then if something were to happen to you, your executor could step in, follow the terms of your trust, and be able to manage the property because it's already named in the trust. That will ensure your assets avoid having to go through probate in California as well as multiple states. The last thing to think about when it comes to having an out of state property or a property that's in California while a probate is happening in another state is that the property that is in California will still have to pay the probate fees associated with the California statutory fees, which are very expensive. So, getting a trust would avoid having to pay those additional statutory fees. If you find yourself trying to figure out what to do when there's out of state property, or if you are even out of state and looking at having to go through probate in California, please call us here at Hermance Law. We are happy to help you.